Hi, and welcome to the first episode of the case study, your weekly fix for understanding the complicated legalities on important cases ongoing before the Supreme Court of India. For the past 1 week, a 5-judge bench headed by the Chief Justice of India, Dr. D.Y. Chandrachud, has been hearing the long-standing issue of who between the Delhi government and the centre really controls the civil servants that are deployed in the national capital. In today's episode, we will break down for you exactly what this case is about, how it originated, and what has been said before the Supreme Court. In 2018, a 5-judge bench of the Supreme Court, headed by the then Chief Justice of India, Justice Deepak Mishra, laid down an important judgment, which had interpreted Article 239AA of the Constitution that confers a special status to Delhi and contains special provisions for how the national capital is to be governed. Article 239AA, which was introduced by way of the 69th Constitutional Amendment, says that the Union Territory of Delhi is to be administered by the Lieutenant Governor, working on the aid and advice of Delhi's Chief Minister and its Council of Ministers. The 2018 judgment laid down two main things. One, it said that Delhi cannot be given complete statehood. And two, it also said that the LG has no independent decision-making power when it comes to Delhi's governance. The judgment, however, did not deal with specific smaller issues like who really controls the civil servants. In 2019, a petition came up before the Supreme Court on this very aspect. But the two judges on the bench at that time, Justice A.K. Sikri and Justice Ashok Bhushan, differed in their opinions, where Justice Bhushan held that Delhi government cannot exercise any power over civil servants. Justice Sikri said that transfers and postings of civil servants from Delhi should be routed only through the CM's office. Due to a split decision between the two judges, the case was then placed before a 3-judge bench, which ultimately referred the matter to an even larger 5-judge bench for further examination. So what is this case about? At the heart of the case is one 2015 notification of the centre. In the 2015 notification issued by the Union government, the centre has excluded state public services from legislative and executive domain of the Delhi government. Simply put, the Modi government, through a notification, said that the Kejriwal government will have no power when it comes to civil servants deployed in the national capital. It is this notification that the Delhi government has challenged before the Supreme Court. The issue becomes more complicated because Delhi has a special status of dual control. The Constitution makes it clear that in the capital, public order, police and land fall under the exclusive control of the centre, whereas on every other aspect of governance, the Delhi government and the centre have to work alongside each other. So what is the hearing before the Supreme Court and what is each side saying? The Delhi government, represented by Senior Advocate Abhishek Manu Singhvi, has told the Supreme Court that the centre is attempting to create a 4th exception through its 2015 notification. In addition to public order, police and land, they are now attempting to exercise exclusive control over administrative services too. Dr. Singhvi has argued that the civil servants in the national capital need to be accountable to the people of Delhi, which can only be done if the civil servants are made accountable to Delhi's elected representatives. Delhi government has claimed that unless a government has the power to create posts, assign them and interchange them, they cannot fulfill the will of the people and cannot function properly. Further, Dr. Singhvi has also given examples of various other capitals around the world, stating that local governments across the countries have the power to appoint and control civil servants and their day-to-day functioning in all forms of government. On the other hand, the centre too has held a very firm ground. Solicitor General Tushar Mehta, arguing for the central government, has said that the centre is a major stakeholder when it comes to governance of the national capital. The Solicitor General has also said that the Constitution recognizes only 2 categories of services. At the union level, called the UPSC, and at the state level, called the SPSC or the State Public Service Commission. There are no separate services for union territories, and all India services officers are the ones that are deployed in union territories across the country. The argument being made by the centre is that union territories are merely an extension of the union and there cannot be a separate public service commission for a union territory like Delhi. The centre has also claimed that Delhi government is attempting to create a false perception that they have absolutely no control over the services. This is pure fiction, far from the truth, the Solicitor General has said. Administrative control by the centre does not in any way interfere with the day-to-day functional control of the Delhi's elected government on the officers. After 5 days of marathon arguments, the 5-judge bench on Wednesday reserved its verdict in the matter. As part of the concluding arguments, the Delhi government claimed that the centre was overreaching in their attempt to control civil services, while the centre said that the issue of referring the matter to a larger, possibly a 7-judge bench, should be still kept open. The Solicitor General, while making this appeal, asked, "We are talking about the national capital. Do we want to go down in history for handing over the capital to complete anarchy?" So what is the Supreme Court expected to do now? To cut a long story short, the Supreme Court 5-judge bench will decide on the validity of the 2015 notification of the centre, whether such a notification can even be issued in the first place. If the notification is found valid, the Supreme Court will effectively uphold the centre's powers to control the transfers, postings and functioning of the civil servants in Delhi. On the other hand, if the notification is found unconstitutional, it means that the Supreme Court has ruled in favour of the Delhi government when it comes to exercising control over civil servants. Quite obviously, deciding this is not going to be as simple. The 5-judge bench will have to delve into finer constitutional aspects of interpreting Article 239AA along with the 7th schedule to determine the extent of powers of both the governments and finally decide who is the real master of Delhi's civil servants. Thank you for watching this episode of the case study. If you like this video, please hit the like button and don't forget to press the bell icon and subscribe to Law Today for more updates about what is happening in the legal world. If there are any specific cases that you want us to cover as part of the case study, please leave your suggestions in the comment section below and keep watching Law Today.